Hello, welcome. I am John O'Brien from the Keystone Contractors Association. It's a beautiful, lovely September afternoon here, and a lot of you taking the time to join us for this workers' compensation presentation. It should be good, should be awesome. I was briefed on it by the presenter, and I'm looking forward to it and looking forward to learning along with the gang here. So, without further ado, our presenter is Edward Tobin.
Tobin.
I'm sorry, Edward Tobin from McConkey Insurance and Benefits. Take it away, Ed. It's all
Thanks,
you.
John.
Yep.
Thanks, John. And I just want to thank everybody for letting us come here today and present to you. Just to give you guys a little bit of a background on me. As stated, my name is Ed Tobin. I'm the Director of Claims here at McConkey Insurance and Benefits. For those of you that don't know, EK McConkey Insurance and Benefits, we are a full-service independent insurance brokerage based here in York, Pennsylvania. We also have a satellite office located in the King of Prussia area. As the Director of Claims, my role is to help large self-insured clients, captive clients manage their claims, mitigate losses, and increase their dividend returns on a claim-by-claim basis. Prior to joining McConkey, I was employed as a workers' compensation defense attorney. So I represented employers, insurers, and third-party administrators, such as yourselves, in workers' compensation litigation throughout the state of Pennsylvania. For purposes of today, what I'm going to try and show you guys is the impact of COVID-19 from a workers' compensation standpoint here in the state of Pennsylvania. You'll note, like anything else in law, the law is late to catch up to growing trends or issues that we're facing on a day-to-day basis. COVID and its impact from workers' compensation is no different. As we sit right now, if somebody were to say to me, is a COVID claim covered under workers' compensation? There's no definitive answer yet. The courts are still weighing that, and that's still circulating through at the primary level, the workers' compensation level, and then it'll obviously work its way up through the appellate level to the Supreme Court at a certain point. What I hope to do with this presentation is to give you a bit of guidance, knowing what we know about workers' compensation law in Pennsylvania as it sits. What could potentially happen if you have a COVID claim come across your desk or come across your office space while you're working, and how is that going to affect you from an employer standpoint, and how to best safeguard yourself if in the unfortunate circumstance you do run into this issue moving forward. So with that backdrop, let me just say, first and foremost, when an employee is injured or alleges an injury on the job here in the state of Pennsylvania, the claim for benefits is governed by one of two bodies of law. The first is the Pennsylvania Workers' Compensation Act, which I'm sure as contractors, most of you are familiar with, either through prior presentations or through your HR departments. Secondarily, there's what's called the Pennsylvania Occupational Disease Act, which I'll give you guys a bit of a background on as well. Any claim for a work injury, that could be a torn rotator cuff, a bruised knee, or in this case, COVID claims are going to be governed by one of those two acts. Now, just in terms of general background on the law and how it's applied to workers' compensation claims, to prevail on a claim, an injured worker must demonstrate, one, that they sustained an injury or an illness, two, that the injury or illness occurred while in what we call the course and scope of their employment. You'll hear attorneys say the word course and scope, or alternatively, they'll say that it was causally connected to their work duties. And lastly, an employee has to demonstrate what we call a loss, that they suffered a loss. For workers' compensation specifically, a worker can only demonstrate a loss in one of two ways. They incurred medical expenses as a result of the injury, or they incurred lost wages. That is, they lost time from work. That lost time was attributable to them recovering from the work injury or being treated for the work injury. And because of that, they're seeking what we call indemnity or wage loss benefits. Now, those are the three tests, or the three pillars of the test that you lay out to make a claim under the Pennsylvania Workers' Compensation Act. Alternatively, we have the Pennsylvania Occupational Disease Act. And what that allows an employee to do is essentially flip the burden on the employer. And essentially what that states is it allows an employee to presume that their illness was causally related to their employment, but they only get that presumption if they hit a few key points. First is that the employee was exposed to the disease by reason of his or her employment. Second, that the disease is causally related to the industry or occupation that they're in, which is similar to the test outlaid in the Pennsylvania Workers' Compensation Act. But lastly, if the employer can demonstrate the occurrence or the disease is substantially greater to be contracted in their industry or occupation than the general population, they'll enjoy the presumption that the work injury, that the specified disease or illness occurred at work. Common examples of this are, think, asbestos removal and its links to form of cancer. Another common example is think of the black lung and its link to the mining industry. If you can show that you're a miner and that you develop the black lung, the courts are more likely to give you a presumption that that black lung disease was the cause of your work rather than some outside force. Occupational Disease Act has come into play a lot more with some of our other clients who are in the healthcare industry or nursing facilities. For purposes of contractors, though, if an employee is going to be able to demonstrate a cognizable claim under the Workers' Compensation Act, it's going to be under that first test that I laid out. So specifically, what an employee is going to have to show to a judge is, one, did the employee in fact suffer COVID? That's likely easily ascertainable by way of COVID testing at this point. Two, and the more difficult one will be showing, was he or she exposed to the virus during the course and scope of their employment? That's that causal connection that we're talking about. And lastly, they'll obviously have to demonstrate they suffered some sort of loss, whether that be medical bills related to COVID testing and COVID care, or lost time from work and wages. Now, as I stated at the outset of this presentation, at this point, Pennsylvania courts have not definitively weighed in on whether a COVID claim can indeed be compensable as a work injury. The major prohibitive factor, as we stated, is showing that causal connection. Historically, cases like COVID or cases of illness or disease have not been brought in a workers' compensation setting. And the reason for that is COVID, similar to the seasonal flu and other communicable diseases, have historically not been litigated due to the widespread potential for non-related transmission. And historically, the seasonal flu, an employee is likely to get over that without much fanfare in terms of medical bills or lost time from work. Therefore, it wouldn't necessarily qualify under a workers' compensation compensable illness. However, COVID presents a new test and a new bear for the court to think about, simply because of the ramifications of potential COVID fatality claims that could come up into the future. Looking at the case law from the Supreme Court of Pennsylvania, there is precedent for the courts to rely on in finding that the infection could in fact be a work-related illness. There's a famous case where a colleague of a female employee gives her a kiss on the cheek at her retirement dinner to send her off into retirement. During that point in time, he actually contracts an illness, meningitis, from that kiss. And the question before the court was whether or not that illness in fact is compensable. And the Pennsylvania Supreme Court stated that it was. He contracted during the course and scope of his employment. It was a disease that he otherwise would not have contracted but for his employment, and it actually resulted in his death. And the court did award fatality death claim benefits based on that fact pattern. So there is a foundation for the court to build on if they were to find COVID claims to be workers' compensation compensable. Now, moving forward here, I know the question is, we've gone through all that legalese in the background, and the real thing that you're worried about as an employer is, well, is it covered or not? I guess I'll give you the lawyer answer at the front end is, it depends. And we're going to walk through a bit of a hypothetical here so I can show you if in fact the courts deem that the COVID-related claims to be compensable under the Workers' Compensation Act. We'll walk through a bit of a scenario here to show what potentially could be deemed compensable versus what COVID-related claims might be denied. Before we do that, though, I do want you guys to understand that this is a presentation, so my employer is happy with me. I will state that this does not specific legal advice and does not create an attorney-client relationship between myself, the presenter, and any of the attendees. While you're watching this, you should not reach any legal conclusions, written or oral, without first seeking advice of counsel. The hypotheticals and the discussions that we offer do not represent law as it currently sits or law as it will be in the future. It's simply an opinion. And specifically, if this were to come across your plate as an employer, we would advise you to seek legal counsel and have them address the specific facts before you make a decision on whether to act or not act. So with that background, we're going to walk through a little hypothetical here I call 3 construction workers go to a job site. So I want you to assume for purposes of this hypothetical that Jeff, Diane, and Tim are all general laborers working on a commercial job site, installing commercial fencing. Over the weekend, our first employee, Jeff, visited his family for a large reunion in Myrtle Beach. He did not disclose this trip to his employer. He felt no symptoms upon his return from the trip, and he reported to work as scheduled on Monday. Jeff, Diane, and Tim all carpool to the job site using a company-issued work truck. On the job site, Jeff and Diane work closely together. They wear their protective equipment, but they often share tools and at times are required to be within 6 feet of each other by nature of their work. Aside from the morning commute, Tim rarely sees the other two, Jeff or Diane. Tim is Diane's supervisor. However, since the pandemic, their meetings have always been outdoors. They've maintained 6 feet or more in distance and always keep their personal protective equipment on when speaking with each other. The question then becomes is, under that scenario, I want you to assume that all 3 employees subsequently tested positive for COVID-19. Assume further that they all required medical care and were out of work for a period of time due to their symptoms. With that backdrop, is Jeff covered as a workers' compensation claim? Likely not. So Jeff has demonstrated that he suffers from the injury or illness, which is COVID. He does have a loss. He was out of work for a period of time, and he probably incurred medical expenses as a result of his COVID treatment. However, the causal connection between Jeff's exposure and contracting the virus is likely the trip that he took to South Carolina and not his employment. This claim would likely be denied from the outset. Is Diane covered? Diane has what we would see the best case for acceptance of a workers' compensation claim. She's demonstrated she suffers from the virus. She's demonstrated that she was exposed to the virus, quote, during the course and scope of her employment, end quote. And lastly, she's demonstrated a loss as a result of that. She's been out of work and she's experienced medical expenses. If COVID is deemed to be work-related, Diane would be the most likely covered under this factual scenario. Is Tim covered? The reason we put Tim into this factual scenario is Tim's exposure depends. As we saw from the fact pattern, Tim's exposure, if any, was during the commute to and from work. Under Pennsylvania's workers' compensation law, a common defense to accepting a claim is known as what's called the coming and going exception. And the reason that exception was put in there is the legislature felt it'd be unfair to hold an employer or an insurer accountable for somebody who suffered an injury as a result of an accident going to or from work. However, if we look at the fact pattern here, Tim's only exposure was likely during that commute to and from work. Given that fact pattern, if the employer did not require Tim to carpool with the other employees to the job site, Tim's chances of acceptance are lower. If, however, the employer required all parties to carpool because they wanted to save money on turnpike costs or wanted all parties to be in the same vehicle together when going to the job site, then Tim's chances of having a covered workers' compensation claim increases. So given that fact pattern, what I try and get people to understand from an employer standpoint is when you're addressing these workers' compensation claims and the potential for COVID claims within your own job sites, facts matter. What we presented here was 3 employees. They all suffered from COVID, and we can pinpoint the spread of that COVID to your job site. However, the facts surrounding each individual employee, how they were exposed, their history prior to exposure, and their status, whether they're in the course and scope of their employment or outside of the course and scope of their employment, at the moment they're exposed, are all factors that are going to guide the decision of compensability from a workers' compensation claim. So with that, and with those potentials out there, a lot of people ask the question of what is our role in mitigating exposure? When I talk to employers about their role in mitigating exposure from COVID and from a workers' compensation standpoint, the thing that I stress is hypervigilance on protecting the safety, the security, and the integrity of the workplace. And people say, okay, those are great plug words. What does that mean? If you're an employer, the thing that you have to make sure that you've done, if you haven't already, is put a plan in place for return to work. That plan in place needs to outline for each type of individual employee, whether they be a desk job, whether they be a job site employee, whether they be an upper level management employee, what is our return to work policy for them? And in shaping that policy, how closely does it align with the CDC, the Pennsylvania Department of Health, and OSHA guidelines on mitigating the risk? This helps you not only from a factual standpoint of mitigating your risk of contracting the virus and spreading the virus within your office or your worksite environment, but it also helps you mitigate liability from a workers' compensation standpoint or from a general liability standpoint. And the reason I stress that is at this point, we have seen 2 cases filed, both in Pennsylvania, one out of the Pittsburgh area, one I believe out of the Philadelphia area, that seek to what they call pierce the exclusivity rule of workers' compensation. So one of the benefits to a workers' compensation case is the only thing that an employee can recover in those settings is wage loss and medical benefits. Nothing else can be recovered in terms of pain and suffering, loss of consortium, or any other ancillary benefits. At this point, what certain plaintiffs' attorneys are trying to do is pierce that exclusivity or rip it away and seek additional benefits. And the reason that they're trying to go after that is by trying to demonstrate that the employer was recklessly indifferent to the realities of COVID, and because of their reckless indifference, put the employee in a hostile or unsafe environment, which led to the contracting of virus. So, when employers ask me all the time, how do I safeguard myself against being sued? The answer is you really can't ever safeguard yourself against a lawsuit. The only thing that you can do is set yourself up to look the best that you can in front of a judge, a jury, or a fact finder when that lawsuit comes in the door, that you did everything possible to be mindful of the safety of your employees, the surrounding circumstances of the COVID epidemic, and then on top of that, that when you had to stray from the CDC or PA Department of Health guidelines, you had a reasonable explanation for doing so. The better you are at preemptively putting a plan in place for bringing people back to work and following that plan, the better off you will be in the future if in fact you do have to respond to a workers' compensation COVID claim or any other type of general liability claim that may be coming at you in the future. In addition to just the general triage and safety from establishing a return to work strategy, the other thing that I tell employees to do is be conservative and over-report your potential COVID-related workers' compensation claims. So a lot of times employees will come to me and say, hey, employers rather will come to me and say, I have this one guy who tested positive for COVID. He thinks he contracted it at work. We don't think there's any possibility. We think he probably got it because he was on vacation, X, Y, or Z. If the employee personally believes that he or she contracted the virus, whether you believe that is true or not, that needs to be reported. And then the adjuster needs to make a fact-finding determination and issue an acceptance or denial on their own. Separately, if you have an employee who does test positive and the employer has reason to believe they were exposed to COVID at work, those should also be reported. In this case, that would be the Diane or the Tim scenario. Those should be reported as you have reason to believe they were exposed to COVID at work, and then the adjuster can make a fact-finding determination based on the law in your jurisdiction and make a final decision on whether or not they're going to accept or deny that claim. The last thing I'll remind employers is that you have a duty to report any work injury or illness within 21 days of receiving notice. So within 21 days of receiving either a positive COVID test for somebody, reasonable tracing of that COVID test to other employees that could have been impacted, or an employee coming to you and saying that they believe they contracted it at work, that starts the clock, and then the responsibility is on you to make sure that you report that work injury and allow those in the investigative portion to go through their fact finding and make a determination on acceptance or denial. So in speaking with adjusters handling COVID claims today, for those of you who aren't familiar, each time that you submit a workers' compensation claim, an adjuster is likely assigned to that, and they'll make a determination typically within 1 to 2 weeks of whether to accept or deny a claim. In speaking with adjusters directly, they've sort of outlined the 4 things that they're looking at when making a major COVID consideration. First is, what's the applicable state law? Right now, Pennsylvania does not have any presumption law on the books. New Jersey, on the other hand, just recently issued new law that presents that presumption that an individual suffered from COVID as work-related if they were an essential employee. So for an individual being assessed under a Pennsylvania standpoint, there's no applicable state law which says they have to take that claim. In New Jersey, however, depending on the industry, they may have to take that claim. So the second bullet point there goes hand in hand with the first. Is the alleged individual who suffers from COVID somebody who's an essential employee, somebody who works in a hospital, somebody who works in a grocery store, or are they somebody who typically works out on their own, away from other individuals, away from areas where they could potentially contract the virus? The industry and how individuals work within that industry will be a major factor on whether or not to accept or deny. Lastly is the factual considerations surrounding the alleged manner in which the claimant was exposed to the job site. And this sort of goes hand in hand with the last point of a specific moment. If a claimant comes in on a random day and states that there's nowhere else they could have got it, they only go to work or come home, and those are the only 2 places that they've been, but they don't know where specifically they contracted it, an adjuster is much more likely to deny that claim on the theory that it can't be pinpointed to a work location. However, if there's a specific moment that they can point to where they were in a vulnerable position on the work job site where they could have contracted the COVID virus, that claim is much more likely to be looked at and scrutinized as potentially being accepted. So I'll leave you guys with just some facts and figures in terms of Pennsylvania workers' compensation, where it stands now, and the effects that it could have from an employer standpoint and from an insured standpoint. As we sit right now, there are 6,396 workers' compensation COVID claims that have been filed to date. Now, that doesn't mean that all of those claims have been accepted or denied. Most of those claims are running through litigation as we speak. Judges are making a determination on whether or not they believe that the COVID virus was contracted at work pursuant to that 3-prong test that I outlined. And once those decisions comes out, it's likely we'll probably see a period of appellate decisions following that and a final determination of whether or not the COVID-related claims will be compensable under the Workers' Compensation Act. In comparison, there were typically, I believe last year, 172,000 workers' compensation claims litigated in the state of Pennsylvania. So 6,000 against the backdrop of 172 is a large amount. However, I do think once we get clarity from the courts, we'll see that amount level out, either at a higher level or at a minimal level if the courts determine that the COVID-related virus is not compensable. From a monetary exposure standpoint, we really have little in terms of monetary exposure on COVID claims to date. And the reason for that is COVID claims where there's not a fatality is a limited window of wage loss exposure, potentially 2 weeks to a month, and a limited window of medical care for a large percentage of these cases. However, what the insurance industry and adjusters are cognizant of is what's going to kick that up are any potential COVID-related death claims, and their overall monetary impact remains generally unknown until we flesh this out as litigation unfolds. So the good news is, absent COVID-related fatality claims, the monetary exposure is going to look a lot less than your typical contractor claim for, a torn rotator cuff or a low back injury. However, it's sort of a feast or famine with COVID. It's either going to be a very low level monetary claim, or in terms of fatality claim, could climb very high and into the excess portions if in fact it is deemed compensable. The last thing I'll leave you with, and it sort of harkens back to my position on being over conservative with respect to your reporting of COVID-related claims is on May 5th, the PA Compensation Rating Bureau actually announced approval that all COVID-19 related claims would not be considered as part of the experience rating calculations. So I know specifically in the contracting industry, your mod rate and that number is important in terms of bidding and in terms of jobs. So people may be hesitant to report a COVID-related claim with the thought that it's going to impact their mods. The Pennsylvania Compensation of Rating Bureau, in an effort to try and gather as much information as they could, has put that at ease at this point. So if you do report a workers' compensation claim, it's not going to be held against you in the future in calculating your mod or in calculating your premium. So guys, I hope that was helpful. I'm not sure how many we have on the line, but if anybody has any questions specific to their industry, specific to things that they've been seeing while out, please feel free to unmute yourself and go ahead and ask.
Any questions? I thought it was very informative and a great education. So thanks for that, Ed.
Not a problem, John. And just so you guys know, we'll forward to John, Brock and I. Brock's also on the line with me. He's a business executive here at McConkey. We'll forward over our information for John so we can hand that out to the group, as well as the presentation in case you guys want to look back on it. If any questions come up in the future, if you guys think about anything else, not just from a COVID-related standpoint, but anything from a workers' compensation standpoint, don't hesitate to reach out to Brock or I, and we'll try and give you guys an update or any advice we can on that.
Awesome. And for the benefit of the podcast listeners, you maybe want to give us some contact information, how they can get a hold of you?
Sure. So for the listeners online, if you want to email me, my direct email is etobin, T-O-B as in boy, I-N, at ekmcconkey.com. And my telephone number, you can reach me directly at 717-572-0305.
Thank you, Ed. This was a great way to spend a Wednesday afternoon. Very awesome. Thanks for the education. And on behalf of the KCA and on behalf of the Building PA podcast listeners, we thank you for your time and your wisdom and your dedication to the industry. Thank you, Ed.
Take care, guys. Be safe out there.
Good to see you. Oops.